fairly much a settlement of all issues in the case, or at least most of the issues in the case. Ms. Locke, can you clarify the current status of this matter?
Yes, Your Honor, we have reached complete agreements with one exception, and that is how Miss Boyce's personal property will be collected from the marital home. The parties could not agree on that, so we're asking the court to hear argument on that today and then issue a ruling.
Okay, using the first names of the parties for clarification, who needs to pick up property?
April Boyce needs to pick up property from Kira.
Okay. Ms. Levitt, would you agree with the announcement made by Ms. Locke regarding the one issue that remains?
Yes, Judge.
All right. As the proponent of needing to pick things up, I'm going to have April's counsel go first. What do you need to pick up, and how are you proposing to the court that you do it?
Thank you, Judge. There is a property list attached to the party's settlement of items that they have agreed that my client still needs to pick up from the marital residence in some form or fashion. That includes everything from personal items left behind that are small and easily packed into a car, through to furniture such as a queen-size bed and some dressers that is going to require something like a U-Haul truck, and the assistance of at least one other person to do so. My client is requesting the right to go to the personal property or the marital residence to pick up her personal property, and because of a couple reasons. One, when this case started, it was served shortly after the divorce was served. The PFA was served in which my client was kicked out of the marital residence. She had 1 hour to gather her belongings with an officer present. And it was an incredibly hectic 1 hour, an emotional 1 hour, and she was focused on taking things such as her clothing and items she would need for work. She had not been able to return to the marital residence until
I'm going to stop you right there. I need to pause for a moment.
Sure.
I'll be right back. I apologize, counsel. This should be short. All right. Everyone could resume. Thank you for your patience. Ms. Levitt,
Yes,
if you
Judge.
continue your argument at this time.
Yes. So my client was removed from the home by way of a PFA. She was given 1 hour to get personal property with an officer present during that time to ensure, of course, that she left in compliance with the orders. She was focused on getting her belongings such as clothing and items for work at that time. The PFA since then has been dismissed, and my client was, by agreement of the parties that they had worked out between each other, allowed to return to the home on August 15th to get some items. And the petitioner's position is that August 15th exchange or property pickup, I should say, did not go well, and this should be the basis for my client not being allowed to return to the home. What I would advise the court is that my client had agreed for a third party to be present at the pickup, which was a woman by the name of Carla Barrier, and she had advised the petitioner that her son would be coming with her. His name is Thad White, but that he would remain in the vehicle. When she arrived for the property pickup, Thad was with my client and he did remain in the vehicle. However, the third party at the pickup was not Carla Barrier. It had been changed by the petitioner to Marcia Barrier without notice to my client. My client said hi to the third party and left it at that. She picked up property. There was no fight. There was no issues between the parties during that pickup. However, we're being advised that my client was inappropriate to the third party, that she brought along her son wrongfully, and that is the concern going into another property pickup. Our proposal is that a neutral third party be hired by my client, such as a private investigator or an off-duty police officer, to be in charge of not in charge of the pickup, the property pickup itself, but to be present and ensure that it remains neutral and nothing inappropriate occurs, that there is no inappropriate conversations or interactions, which again, my client is offering to pay the cost of. The reason why she wants to actually go to the marital residence to get her property is to ensure that she's actually getting all of her belongings. Otherwise, what's going to occur is potential future litigation when the petitioner packs everything up, places it in a storage unit or a moving truck or a pickup truck or something for my client to receive, and then my client has to inventory all of that, and if items are missing, we have to litigate that issue. This allows my client to go to the marital residence that the parties lived in for 8 years together, that she had only 1 hour to get out of, and has barely been back to since then, get all of her belongings, and anything that she leaves behind at that point can be considered abandoned and done. As to the concerns as to who might come with my client, or the petitioner not wanting to interact with my client, I think this past weekend really undercuts that. This past weekend, my client's son, who is an adult, I do want to be clear on that, he is over the age of 18, but my client's son had a BMX tournament.
Our grandson did.
A grandson did, excuse me, but the child of my client's son who was present at the pickup had a BMX tournament. The petitioner voluntarily showed up to that event knowing that my client was going to be there because it was her children and grandchildren who were doing that event. She briefly interacted with my client at that event with no issue, and she interacted with my client's son at that event with no issue. We've been told by the petitioner she wants to maintain a relationship with my client's children and grandchildren. And yet we're being told that my client bringing her son to the pickup was one of the issues that was inappropriate, and that is compelling them to say she shouldn't be allowed at the residence, and that my client was not appropriate with a third party. I think those issues are addressed by the fact that it would be a professional, and that the person who my client would have come with her is her son, Thad White, who the petitioner knows and by this weekend has demonstrated wanting to continue an ongoing relationship with, and clearly does not have concerns or fear of if she voluntarily went to his child's event and interacted with him. We believe that she should be allowed to go to the marital residence and move herself out. I think that that's a dignity that in this divorce, both parties should be entitled to, and the petitioner is just fortunately not having to move out of the marital residence because it's being awarded to her. But to have the right to pack herself up and move her belongings out and ensure she gets everything at her own expense is something that we do not believe is too big of an ask. We think it's appropriate under the circumstances. The PFA was dismissed. These parties have reached a settlement, partially through mediation, partially through counsel, but ultimately through their own accord by starting to get along and see eye to eye. There is not a risk here when we involve that neutral third party, and we're just asking for that right. And again, I would emphasize, I think it'll eliminate any issues post-divorce decree that there is property unresolved being withheld from my client or wrongfully disposed of in any way, because the burden will be exclusively on April to ensure that she has gotten what she wants and that one go, and that anything left behind is done. That's abandoned, and it's either the petitioners or the petitioner can dispose of the same.
All right, Ms. Levitt, a couple of questions come to mind. Is a date and time for the pickup already established?
It is not, Judge, because the petitioner had suggested, and I don't want to put words in Ms. Locke or her client's mouth, but the petitioner had suggested that the property be moved to a storage unit, which would not necessarily require a set date for the petitioner to do it, whereas a pickup from the respondent going would require a set date to do so. And so we had not picked one because it'll ultimately depend on what you decide. My client can schedule the same quite quickly. We would likely pick a Saturday or maybe a Friday, depending on a Saturday would be better with her work schedule. That would be preferred.
Every detail is under the spotlight. Will her proposal hold up or break?
I don't know, Judge, that I can coordinate a neutral third party for this Saturday plus a U-Haul. It is more likely that the 4th I could coordinate all that for. That would be so this Saturday is September 27th. So actually the Saturday after October 4th would be far more likely to have both of those parts properly scheduled.
All right. Second, it would appear that there is a detailed, itemized list of items of property that your client's allowed to pick up. Is that correct?
Yes, Judge, that is correct.
And does she understand that she'd be limited to the items on that list?
Yes, Judge. The only thing that I'll tell the court that I believe is detailed enough, and the parties don't have a disagreement on this issue, but just for the court's sake, is there is an item listed as April's personal items: clothing, shoes, pictures, small hair accessories, jewelry, personal framed pictures, etc. I suppose theoretically that could cause dispute if they both say that a certain family picture belongs to both of them. but we actually do not foresee that occurring. I think it's quite clear to the parties what is petitioner's property when it comes to personal items and what is respondents. But besides that list, everything else on the list is very clear, and my client understands that those are the only items she's allowed to remove from the home.
Thank you, Ms. Levitt. I'll turn to Ms. Locke at this point. What is your client's position regarding the proposal that's been made to the court this morning?
Yes, Your Honor. Obviously, we're here today because my client disagrees with the proposal. When this case was served on the respondent, the temporary order said that the marital home would be where my client would reside. April Boyce then barricaded herself in the home. She changed the locks on internal doors. She refused to leave the house, despite attempts by the police to ask her to leave voluntarily. She made accusations that my client abused her, which ultimately led to the PFA being filed and her being removed from the home. After she was removed from the home, she requested pretty significant amounts of personal property, so clothing, personal items, those types of items. Miss Kira freely gave those to her, brought them to my office. An individual from Miss Levitt's office picked those things up. We reached a property settlement agreement as far as personal property goes very early in this case, approximately 5 months ago in April. However, April never came to pick the items up. She never wanted to pick them up. She never made arrangements to pick them up. Since then, she's been out of the marital home for 7 months. She's had 60 days in a rehab facility. And the long and short of it is that my client doesn't feel safe with her being in the home. Emotionally, they have separated from each other. She is not comfortable with her returning to the home, with her disrupting Kira's life that's going on in the home, including their animals and their pets that are all being awarded to Kira. What we have proposed from the beginning is that Kira move all of the items of personal property, which have been agreed to and are known. These two have different styles. There's no confusion about whose clothes are whose or whose personal items are whose. They know that very clearly. That those items get moved to a storage unit, which my client will pay for a month of the storage unit. That way, April can, at her own schedule, pick up the items or continue to store them there. We don't know where she's living and if she even has the capacity to have all of these large items in her current home. She would have a month to remove those things, or she could maintain the storage unit after the first month. This is a clean way for the parties to separate from each other. Again, there's no concerns about the personal property or what needs to be picked up. And just for the emotional and stability in the home, it would be a clean separation, and that is what my client is requesting. It's also important to note that in April's prior marriage, this is the precise way that her and her spouse divided personal property. He got a storage unit, her stuff was put in the storage unit, and then she later was able to pick it up. So this is not something, to my knowledge, that is new to her. And so that is what we are requesting the court order today.
Very well. The court has obviously been presented with two separate proposals, each purported to carry out what needs to be done, and that is for April to pick up her items from Kara or her residence. The court finds that Ms. Levitt's presentation makes the most sense. Number one, why move these items twice? Kara's proposal in this case would cause her to have to move it to a storage unit, and then April would have to move from the storage unit to whatever new location or residence that these items need to eventually go to. Number two, she used to live in this residence. It does not seem unreasonable to the court that she gets one more opportunity to go back to the residence that she previously inhabited to pick up her things. And that's what we're here to accomplish. Number three, the court notes that there may have been an incident in the past. That is in the past. We go forward from here. And I would expect that April in this case will behave appropriately when she goes to the house and picks up her things. It's a very simple thing. She's moving some things out pursuant to a detailed list. Furthermore, the court is even more comfortable with this because of the specific proposal that Ms. Levitt made that there would be this professional security person on site. Quite frankly, this court would prefer an off-duty law enforcement officer over a private investigator, though I do understand private investigators in many instances perform services similar to this. And I also know that an off-duty police officer may not be available on the short notice that they're going to be given in this case. But there is an absolute must to have this neutral third person to be a security presence at this location to keep the peace. And I think their very presence would be a deterrent to any acting up from either party. So what the court will do is adopt Ms. Levitt's proposal. Furthermore, the Saturday, October 4th seems to be a very practical time. What are you proposing regarding time of day, Ms. Levitt? 10 a.m.?
A 10 a.m. start would make the most sense, we believe.
What would your estimate be, Ms. Levitt, as to how long this is going to take?
Where's maybe max?
4, maybe 5 hours. 4 seems sufficient in my client's eyes.
Okay, how much help is she going to bring with her?
Well, Your Honor, she's going to need at least one other adult with her because there's a queen bed and dressers and some bookshelves to move.
And the hutch is pretty big.
And a fairly large hutch. So she's going to have to bring at least one adult with her. She would prefer to at least bring 2, quite frankly, just to ensure that none of this property gets damaged in moving out. But if the court feels comfortable with only one individual
Kira's side strikes back, raising safety fears and storage plans.
being there, and if it's just one, it would be her son. If it's 2, it would be her friend Michelle Davis and Miss.
They're out of town. I might just hire some people.
That or she could hire professional movers, is what she just advised as well.
From what you're describing, 2 big guys, it seems to me, are going to be necessary. You got some very heavy furniture that you're moving from just your description.
Correct.
Make sure that you have adequate help. And certainly your son is approved to be one of those. But
Thank you.
I'll remind April that you're responsible for his behavior. And I think there needs to be a pretty strong session with him beforehand about how his behavior will reflect on you.
Absolutely.
And that he needs to make sure he conducts himself appropriately at all times. And
Absolutely.
the court would also authorize another appropriate person to provide help with the lifting and carrying. So no
Yes,
more
Your
than
Honor.
3. And
Yes,
that
Your
means
Honor.
that's everyone on site,
So
no more than 3.
Then we'll have the neutral third party off-duty officer.
Correct.
And then, of course, that does not include the security officer who's simply there just to perhaps have a copy of the list and make sure things are running smoothly. All right. And I want to make sure, Ms. Levitt, that person that's going to be the security presence at this location is designated well in advance. And Ms. Locke needs to know as soon as that person is selected.
Yes, Your Honor, we
I
will be
doubt if she's
reaching
going to
out.
have any objection to anyone that you would hire for this.
We
But
will
I
be
think
reaching
they have
out
every right to know.
to individuals on scheduling here today, tomorrow, as soon as we can get them to respond to us and who's available on October 4th. And then we will share that individual's name and information with Ms. Locke.
Okay. And I also think that as a courtesy, they should know in advance exactly who those 3 people will be on site to do the moving. As soon as those persons are determined with certainty, then you need to let Ms. Locke know exactly who those persons will be. Then the court will expect and in fact order complete cooperation from Kara in this place as far as making sure that the move is going to go smoothly starting at 10 o'clock a.m. on October the 4th.
Judge, and I'm fine either way, I just want it for clarity's sake. Do we need any orders on if petitioner is allowed to have someone there alongside her and
Oh,
notice who that may be?
well, okay, I'll let Ms. Locke address that, but the security presence that we've talked about would help ensure that she doesn't feel unsafe or insecure in any way. But I'll hear from Ms. Locke on that. I'll just make the observation that the more people that are on site, the more potential there is for a problem. But
These are
Ms. Locke,
that won't become a problem.
Your Honor, my client would like to have either her mother or her sister there with her, potentially just to watch the dogs, those types of things, while property is being moved in and out of the home.
all right, Ms. Levitt?
Your Honor, the last time the parties did a property exchange, petitioner had the dogs removed from the home. They weren't even present there. And there has been conflict with petitioner's mother and sister before, with things that have been said and inappropriate comments towards my client. And we think that that could cause issues. I understand that there'll be an off-duty officer there, but I'm also not trying to place him in a position where there could be known conflict before everybody even gets there. So if the court is going to approve those individuals, we'd ask that it just be one,
I would say Heather,
which is,
her sister Heather, I would.
and
be with.
my client says that she believes that sister would probably be less of a conflicted issue than petitioner's mother.
Heather.
Okay, is Sister Heather one of those persons that you suggested, Ms. Locke?
Your Honor, it was not. It is my client's sister, Andrea, who is readily available to be there on this date.
Well, has there been conflict in the past?
Your Honor, when there were accusations made about my client allegedly abusing April, rather than call the police, she called my client's mother. So to my knowledge, there have not been issues. We were not given an opportunity to object to her bringing her son, and we won't object. But this is precisely why we suggested that there just be a clean move with no one there. So we are requesting that my client be allowed to have a family member present.
Okay, and what would this person's role be exactly?
Be there to support my client, help move things if that is necessary, to help with the dogs while things are going in and out of the house. The parties have 4 dogs. They were all present last time April was in the home collecting her property. She will have her child there instead of neutral people. And so my client is suggesting that she also get to have someone there with her.
Can't the dogs just be in a backyard or outside the house completely while a move is going on? I don't see how the dogs would facilitate orderly and efficient moving of property. So I mean,
Agreed.
is there a backyard fence where they can just simply be let outside while the move's going on?
Yes, Your Honor, it is a 4-hour period, and with our recent weather, there could be challenges to having the dogs outside for 4 hours. Again, this is the party's marital home. My client will be there, and she would like to have another individual there with her. This person will not interfere. My client understands the court's direction to not make this more difficult than it is.
I think if she wants to have one person there, apparently the mother is considered to be a greater potential for problem. So let's make it the sister that your client designates, Ms. Locke. But she's to stay out of this. She isn't expected to help move anything. That's not
Understood.
her role. I don't know that there needs to be any verbal exchange by this person with anyone that's doing the moving. So if they want to stay in the background and help with the dogs, fine, and provide some emotional support to your client, Ms. Locke, the court will allow it.
Thank you, Your Honor.
She just needs to stay out of the way.
Understood.
Okay. Ms. Levitt, I think that this pickup order needs to be a separate order than any decree that issues from this case, rather than have this placed in paragraph 34 of a decree.
It's the dramatic climax with fairness weighed against raw emotion.
I want this to be a separate, distinct order that you draft.
Judge, I can do that, and then if the court will allow me, a day or two to do it, I can actually put the names of the individuals even in the order.
All right. Which would be preferable.
Okay.
All right. I think that we've resolved all of the issues concerning the moving of property. Good luck, April. I hope everything goes smoothly with this, peacefully, non-harassing. Just get your stuff out of there to help end this relationship. Then you can all go your separate ways after that.
Thank you, Your
All
Honor.
right. I don't think we've had a hearing on the petition. Ms. Locke, are you prepared to go ahead and present evidence in support of your petition at this time?
Yes, Your Honor, and we, I believe, are in agreement to put the settlement agreement on the record if the court would like to hear the same.
Is there a written document?
Yes, Your Honor.
Okay, all right. Then I'm going to go ahead and administer an oath to your client. If she'll raise her right hand, please. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Okay. Ms. Locke?
Please state your name for the record.
Kira Boyce?
And Ms. Boyce, are you the petitioner in this matter?
Yes, I am.
And who is the respondent?
April Boyce?
Have you been a resident of the state of Kansas for the 60 days preceding the filing of the petition?
Yes.
And have you been a resident of the state of Kansas since filing the petition?
Yes.
Has the respondent been a resident of the state of Kansas?
Yes.
Did you cause respondent to be served with your petition about February 18th of 2025?
Yes.
Were you legally married to the respondent on February 22nd, 2020?
Yes.
Are you asking this court to grant a decree of divorce of and from the respondent on the grounds of incompatibility?
Yes.
Are there any minor children of the marriage?
No.
Are you pregnant?
No.
To your knowledge, is Miss Boyce pregnant?
Not to my knowledge.
Have you and the respondent worked to resolve all of the marital assets and debts?
I believe so, yes.
Have you reached a property settlement agreement?
Yes.
Have both of you agreed to waive any claim of spousal maintenance or spousal support?
Yes.
Have you agreed that you will maintain your car, your bank accounts, and all other financial accounts listed in your individual name?
Yes.
Have you agreed that you will maintain the animals of the marriage, including 4 dogs?
Yes.
And have you agreed that you will also be the sole owner of the real estate located in El Dorado?
Yes.
Has respondent agreed to retain the following personal property: her vehicle, your RV, and all of the bank accounts in her individual name?
Yes.
Have you also agreed on a property settlement agreement that includes personal property?
Yes.
And you understand the terms that the court just set forth as far as April collecting her personal property?
Yes.
Have you agreed to maintain as your debt and sole obligation the mortgage, utilities, and expenses associated with the home?
Yes.
Credit cards in your name?
Yes.
Your bank loan for your vehicle?
Yes.
And your 2025 state and federal tax obligations?
Yes.
Are you also agreeing to maintain as part of an equalization the debt on the RV that will be assigned to the respondent?
Yes.
Has the respondent agreed to be responsible for her personal living expenses?
Yes.
The Verizon wireless outstanding balance associated with purchases made by her and her children?
Yes.
Medical bills in her individual name, as well as medical bills or outstanding debt for her children while they were covered under your health care plan?
Yes.
Her 2025 state and federal tax obligations?
Yes.
And all other debts in her name incurred prior to the marriage and since separation?
Yes.
Do you agree that anything that needs to be refinanced, you will both work together to refinance to remove the other party's name from those debts
Yes.
within the 90 days of the decree?
Yes.
And in order to equalize the marital estate, are you agreeing to pay to the respondent $28,000 within 90 days of the date of the decree?
Yes.
And are you requesting that your name be changed as a result of this final journal entry?
No.
To your knowledge, is April Boyce requesting her name be changed as a result of the journal entry?
I don't know.
Do you believe that the agreement that you reached on property settlement is just and equitable in all respects?
Yes.
Was it freely and voluntarily made?
Yes.
And are you asking the court to adopt the same?
Yes.
No further questions for this witness, Your Honor.
Very well. Ms. Levitt, do you have additional questions for Kara?
No, Judge.
All right. Ms. Locke, do you intend to present any further evidence?
No, Your Honor.
Ms. Levitt, do you?
Your Honor, I would just briefly put my client on the record, especially to address so that it's clear on the name change since the petitioner was uncertain.
All right, then I'll have April raise her right hand so I can administer an oath to her. You do solemnly swear that the testimony you are about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, I do.
Okay, Ms. Levitt?
Ma'am, are you April Boyce?
Yes, I am.
And are you the respondent in Butler County case 2024 DM 406?
Yes, I am.
Have you heard the recitation of the property settlement agreement put on the record by petitioner here today?
Yes, I have.
Do you agree that that is the property settlement agreement that you have reached in this divorce matter?
Yes, I do.
Do you believe that it is fair, just, and equitable?
Yes, I do.
Are you asking the court to approve the same today as the agreement of the parties in the order of the court?
Yes, I do.
And are you in agreement that the parties are incompatible and that is the basis for which a divorce should be granted today?
Yes, I do.
Okay, and then just a few clarifying so the court can make sure that its record is correct and complete. Ma'am, are you presently pregnant?
No, I'm not.
Okay, and as to your name, do you intend to remain April Boyce following this divorce?
Yes, I do.
So you are not requesting a name change?
No,
today?
I'm not.
Judge, there's nothing further that I have for the respondent.
Ms. Locke, any questions for this witness?
No, Your Honor.
All right, very well. Ms. Levitt, do you intend to present any further evidence?
No, Judge.
The court finds from the evidence presented that the parties are incompatible and that the petitioner shall be granted a final decree of divorce from the respondent. On the legal ground of incompatibility, the marriage of the parties is hereby declared to be dissolved. The court further finds that the division of property and debt is fair, just, and equitable to both sides. The court approves the parties' property settlement agreements and make those the orders of the court. Implicit in the court's orders today is its reaffirmation of the earlier orders made by the court regarding the pickup of personal property, which is going to be handled by separate order. No name change is contemplated by the parties at this time. I'll point out to the parties that under the laws of the state of Kansas, they are not divorced based on this oral pronouncement, but rather when their decree of divorce is actually submitted to the judge approves it, and then it's filed with the clerk's office. It is the filing of the decree, which is the legal act which divorces you under Kansas law. And then for a period of 30 days thereafter, neither one of you should try to remarry. Any marriage you would attempt to enter into during that 30-day period would be voidable under Kansas law. So wait at least 30 days past your decree's filing date to attempt to enter into a new marital relationship. Again, I hope that the property exchange goes smoothly. It may be your very last item of business between you two. At least perhaps that can go smoothly so that you can get on with your lives. Good luck in that regard. All right. Ms. Locke, you'll be submitting the divorce decree to the court's queue today?
That would be my intention, Your Honor. And Jessica, I just added a sentence that says the terms of collection of personal property will be subject to the court's order.
Okay, that's fine.
All right.
And then, yes, Judge, I will be sending my client and my signatures back to Ms. Locke today so she can submit them.
All right. Very good. Ms. Levitt, is there anything further that you believe you need to address the court about at this time?
No, Judge.
Ms. Locke, anything further?
No, Your Honor.
And if there's nothing further at this time, the Boyce matter will be in recess and this meeting may be ended for all.
The divorce is final, closure, relief, and the chapter ends here. And guys, if you enjoyed this breakdown, hit like, subscribe, and we'll see you in the next video.